database, February 2022 report. So according to the query on which countries are the biggest users of the PCT system. So which countries are trying to file more and more patents internationally, trying to file patents in multiple countries. So as per this query, the result is around 2,77,000 PCT international applications were filed in 2021. And among these filed applications, China has filed 69,540, followed by United States 59,570, then Japan 50,000, Republic of Korea 20,000, Germany 17,000, France, UK, Switzerland, Sweden, Netherlands in and around 4,000 to 5,000 average. And these top 10 countries constitute about 88.1% of the total filings in the world in the last year. So this also implies that China, US, Japan, and these top 10 countries which are mentioned, they are going to rule the world in the near future. Because if their technology gets granted, so any person in that country, if he wants to use that technology, he will have to give the royalty to the inventor or the applicant of that particular invention. So this is like becoming a knowledge power throughout the world. So if, as you can see, China is already number one and it is filing the maximum PCT applications. Obviously, it will rule the world as per these statistics. So so in further slides, I will share where India stands. And one more query which was posted on this WIPO statistics website: which countries specialize in which technologies? So, okay, we have come to know that China, US are filing the highest applications. Now, in which technology are they want to gain the monopoly? So, computer technology, electrical machinery, apparatus, energy, digital communication, transportation, medical technology, measurement, audio-visual technology. So these are few of the top priority technologies which are being targeted by these top countries: computer technology, electrical machinery, digital communication, stuff related to supply chain management, transportation, medical technology, measurement, audio-visual technology. Now, which are the companies which lead this PCT international patent filings? So Huawei Technologies, followed by Qualcomm Incorporation, then Samsung Electronics, LG Electronics, Mitsubishi Electrical Corporation, Oppo Mobile Telecommunication, BOE Technology, and etc. And which IP offices are receiving the most patent applications? So here you can see more than 85% of all the patent filings in 2020 occurred in the IP offices of China, United States, Japan, Republic of Korea. And patent applications for the top 10 offices where the patent activity was highest. So here you can see China is ranked 1, followed by US, and India is ranked at 7th place. So India is a potential market for the other countries to gain monopoly over their inventions. So here we are standing at 7th place. So it also means that India is a good market of potential buyers for their products. 1 second. Yeah. So so you can see that patent activity was highest in India. It means that people have targeted India as one of the country where they want to file the patent. See, when it comes to PCT application, you have 288 countries, or you have all the signatories, all the countries who are part of this PCT treaty. You can file patent in multiple countries. So when there is a choice of selection of countries, people select India at the seventh. India is favorite at the seventh place. So more than on an average of 6% of total filings come to India. So in the last year, 56,771 applications were filed only in India from international, from outside India. And in this slide, I have made a comparison of last 5 years between India and China. So India is filing on an average of 75,000 patents per year, whereas China is filing on an average of 1.5 lakh filings per year. And when it comes to today's important topic, that is artificial intelligence, the total number of patents which are already granted are which are related to artificial intelligence are 3,49,099. And which are the top applicants which have patents related to AI/ML? Samsung Electronics has 16,000, IBM has 12,000 patents, LG Electronics has 6,000, Microsoft Technology has 5,900. And top owners, you can see IBM having 11,167 granted patents, Samsung Electronics again 9,300, Microsoft Technology 7,900, AT&T 5,500, and etc. So these are the top companies which have the maximum AI/ML granted patents. So you must be surprised with the huge numbers. 3,49,000 patents are already granted in the field of artificial intelligence, and this data has been taken from Patent Scope website, and it has been taken just 5 minutes ago. So this data is for today's data. And who are the top inventors or top agents? You can see the list. Henry Paul, Irwin, Farhad, Milius, Little, Thomas, Robert. So all these are top inventors in who have the maximum inventions related to AI/ML. So coming with some introductory videos on what is invention, what is design, copyright, etc. First, I'll begin with a video on AI/ML latest technologies or inventions which are available. Sir, is the video audible and visible?
Sir, it's not, sir. Video is not visible, sir. No, sir. Audio is visible. Audio is we can.
Okay.
Yeah.
Sir, now?
It's started screen sharing, sir.
Okay, video is visible.
1 second, sir. It's going to. Now we can play, sir.
Yes.
Welcome to Next. In this video, we're going to show you 5 amazing AI technology which will dynamically transform into unavoidable technologies. But how? 5 years back, the idea of self-driving cars was only a fantasy. Now they have become a reality and relatively ubiquitous, even though there is so much that is in the pipeline. Technologies can transform in the blink of an eye, and artificial intelligence is no exception. People are fast adapting to artificial intelligence technologies for the predictive capabilities it has and the convenience it offers. Businesses are equally warming up to it, either in the hope of improving overall performance to earn higher ROIs or as an unavoidable necessity. Here we discuss the top 5 artificial intelligence technologies that will shape-shift in 2023. So let's begin. Number 1. Autonomous vehicles. AI is the brains that will guide the autonomous cars, boats, and aircraft that are set to revolutionize travel and society over the coming decade. 2022 should be a year to remember when we look back in the future and contemplate with horror the fact that we thought it was normal that 1.3 million people died of traffic accidents every year, 90% of which were caused by human error. As well as increasingly effective autonomous cars, Tesla says its cars will demonstrate full self-driving capability by 2022, although it's unlikely they will be ready for general use. Its competitors include Waymo, created by Google, Apple, GM, and Ford, and any of them can be expected to announce major leaps forward in the next year. Number 2. Facial recognition. A facial recognition system is a technology capable of matching a human face from a digital image or a video frame against a database of faces typically employed to authenticate users through ID verification services, works by pinpointing and measuring facial features from a given image. Our favorite devices like our phones, laptops, and PCs use facial recognition techniques by using face filters to detect and identify in order to provide secure access. Apart from personal usage, facial recognition is a widely used artificial intelligence application even in high security-related areas in several industries. Number 3. Artificial intelligence in robotics. Robotics is another field where artificial intelligence applications are commonly used. Robots powered by AI use real-time updates to sense obstacles in its path and pre-plan its journey instantly. It can be used for carrying goods in hospitals, factories, and warehouses, cleaning offices and large equipment, inventory management. Number 4. Artificial intelligence in gaming. Another sector where artificial intelligence applications have found prominence is the gaming sector. AI can be used to create smart, human-like NPCs to interact with the players. It can also be used to predict human behavior, using which game design and testing can be improved. The Alien Isolation games released in 2014 uses AI to stalk the player throughout the game. The game uses 2 artificial intelligence systems, Director AI that frequently knows your location, and the Alien AI driven by sensors and behaviors that continuously hunt the player. Number 5. AI application in e-commerce. Personalized shopping. Artificial intelligence technology is used to create recommendation engines through which you can engage better with your customers. These recommendations are made in accordance with their browsing history, preference, and interests. It helps in improving your relationship with your customers and their loyalty towards your brand. AI-powered assistants. Virtual shopping assistants and chatbots help improve the user experience while shopping online. Natural language processing is used to make the conversation sound as human and personal as possible. Moreover, these assistants can have real-time engagement with your customers. Did you know that on Amazon.com, soon customer service could be handled by chatbots? Fraud prevention. Credit card frauds and fake reviews are 2 of the most significant issues that e-commerce companies deal with. By considering the usage patterns, AI can help reduce the possibility of credit card frauds taking place. Many customers prefer to buy a product or service based on customer reviews. AI can help identify and handle fake reviews. With AI being incorporated in different fields and businesses, it has made a tremendous and remarkable impact in every industry as it automates most of the process without much human intervention. The graph of AI technologies is expected to rise in the coming months as it is widely accepted by the people around the world and everyone looks forward to growing their business with the help of AI technology. We hope you found this video informative and interesting. Do you
Naveen sir, is the screen visible?
Yes, sir. It's visible, sir. PPT presentation.
Yes, sir.
Yeah,
So now
that's a
coming
patent.
to, yes, sir. Now coming to introduction to patents. So every one of you would have heard this term several times. Patents, designs, copyrights. So can anyone from the audience say me anything about the patent? Anywhere you have heard this term patent? Any participant? Sir, Naveen sir, participants has students as well as faculties, right?
Yes, sir.
Mix of faculties
I
and
informed them, sir. If they have any questions, they're going to message in a chat box, sir.
okay, sir.
I'm waiting for any question. Yes, sir. Yes, sir. Only the please, sir. No.
Okay, sir. So when it comes to patents, it is a type of intellectual property and it is intangible in nature. So when it comes to classification of properties, we have two different categories of properties. One is tangible and another is intangible. Tangible refers to measurable quantities like cars, buildings, mobile phones, anything which is visible to your eye. We can call them as tangible. And when it comes to intangible, it is not measurable. For example, intellectual properties. So these intellectual properties can be in the form of patent, designs, copyrights, trademarks, geographical indicators, trade secrets, etc. So what do you mean by this patent? So patent is a type of intellectual property right, exclusive right or monopoly privilege, which is granted by the government. Now this is granted by which government? Suppose I apply an Indian patent, I will be getting grant over my invention by government of India. If I apply an US patent, I will be getting grant by grant certificate by government of US. So it is territorial in nature. You cannot say that I have this patent and it is given from the it is applicable throughout the world. It is not so. No patent is granted having the international patent. You have international application, like I said, PCT route is there to file a patent in multiple countries, but it is subjected to the government and it is subject to their patent laws to grant the patent. One patent may be granted in India, but the same patent may not be granted in USA, depending upon the variation in the laws. So it is an exclusive right or privilege given to the patentee by the government for a period of 20 years from the date of filing, and it is for the commercial gain. And when it will be given in full consideration of full disclosure of the invention. So does it mean that if you disclose your invention properly, you will be getting the patent over it? No, it is not so. Again, there are different sections as per Indian Patent Act. Section 3, which clearly says which are the inventions which are not patentable. And section 4 clearly says inventions related to atomic energy cannot be considered for giving patent rights. So which we will be seeing in detail. What is the difference between invention and discovery? So discovery means finding or exploring something which already is existing, and discovery has no technical effect, whereas invention is something which is new product or process. So here process is referring to a chemical composition or a drug composition. Suppose I come up with a medicine for fever, that chemical composition is called a process. So a new product or process which should be useful and which should be novel. Novel means anything which is new and which was not known to you before the date of filing. Suppose today I file an invention in any part of the world, the similar idea or concept should not be present in any format, either in video format or in textbook format or in any written format. It should not be present. Suppose if anything is already present similar to it, then the patent may not be granted, because to get a patent for your invention, it should have three important things. First is novelty. Second is it should have industrial application. Industrial application means it should be able to be manufactured in the industry or being used in the industry. And third is inventive step. So when I say inventive step, it should be something which is non-obvious to a person who is skilled in the art. And inventive step also refers to the technical advancement in the field of science. So invention means a new product or process which is useful, which is novel, which is non-obvious, which is not known to the public before the filing date. So what can be granted? All products, processes which are new, involving inventive step, capable of industrial application, and which doesn't fall under Section 3 and Section 4 of the Indian Patent Act 1970. So new means, as I said, which should your invention should not be published in India or elsewhere in prior public knowledge or prior public use within India or any part of the world. Inventive step, a feature of invention that involves technical advancement as compared to the existing knowledge, or having economic significance, or having both, and also that makes invention not obvious to a person skilled in the art. So industrial application means being capable of being made or used in the industry. So what is this section 3? When I apply for an invention, the controller directly goes to section 3. If it falls under section 3, then you are not going to be granted the patent. So section 3 of Indian Patent Act 1970, inventions not patentable. So the following are not inventions within the meaning of this act. An invention which is frivolous or which claims anything contrary to the well-established natural laws. So suppose I file a patent which has no input and which is only giving me output, then such category of inventions will not be granted a patent because it is against the natural laws. Or if I come up with an invention which is against the gravitational law, so which is a very well established law. So in such cases, my patent is considered to be imaginary patent and imaginary, and it will not be processed by the controller of examiner. And 3B, section 3B, an invention, the primary or intended use or commercial exploitation of which could be contrary to the public order or morality, or which causes serious prejudice to human, animal or plant life or health or to the environment. So my invention, if it is causing harm to any human life, animal life, plant life, or to the health of the living beings on earth, such inventions will not be considered for granting the patent. They will be rejected. Your application will be rejected. For example, if I come up with a method to commit theft, or if I come up with a method to commit suicide, or if I come up with a method to do mass destruction. So such kind of intentions which are harming people, animals, plant life, etc., will not be granted the patents. Section 3C, the mere discovery of a scientific principle or the formulation of an abstract theory or discovery of any living thing or non-living substance occurring in nature. So anything, any discovery cannot be considered as an invention. So anything which is already available in nature, you cannot claim it as your invention. Section 3D, the mere discovery of a new form of a known substance which does not result in the enhancement of the known efficacy of that substance, or the mere discovery of any new property or new use of a known substance, or the mere use of a known process, machine or apparatus, unless such known process results in a new product or employs at least one new reactant. So you people are aware in chemistry there are different forms of the same substance. For example, salts, esters, ethers, monoforms, metabolites, isomers, mixtures of isomers, complexes. So wherein you are coming up with an invention combining two different salts, different forms, combinations of the salts or different forms of the same substance, then also it will not be considered for the patent unless there is any significant efficacy. So efficacy means a vast improvement should be there in terms of result and there should be minimum side effects. So section 3E, a substance obtained by a mere admixture resulting only in the aggregation of properties. For example, I take a tablet of fever and I take one more tablet of headache and I combine both the compositions and I say this new tablet cures headache as well as fever. So I am just combining two things and making it a third thing. So such things will not be considered as for patent because you are just making aggregation of the properties of the components. 3F, the mere arrangement or rearrangement or duplication of known devices, each functioning independently of one another in a known way. So section 3F again says that if I combine two components, suppose I combine a pen and a pen drive, and I say this is a new category of pen available in the market. You can use one side to write something on the paper, and another side you can use it for storing some data. So this is something new which is not present. But we all know that pen drive and this pen are just linked together, but they are functioning independent of one another. There is no connection between the pen drive and the pen. They have just combined two products. So when you are making such arrangement or rearrangement where you are just combining the two components, such inventions will not be granted a patent. So section 3H, a method of agriculture or horticulture. So if you come up with a process of method to carry out agriculture or horticulture, it will not be considered for an invention. However, if you come up with a product or a device to carry out agriculture or horticulture, again, if it satisfies the three criteria of novelty, inventive step, and industrial application, then it can be considered for an patent. Then section 3I, any process for the medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human beings, or any process for a similar treatment of animals to render them free of disease or to increase their economic value or that of their products. So if you are coming up with a treatment of any plants and animals, then that will not be considered as an invention. However, if you come up with a product or a medicine, then it will be considered for the patent. Section 3J, plants and animals in whole or any part thereof other than microorganisms. See, genetically modified microorganisms will be considered for patent. For example, you have come up with a vaccine for corona. So that is genetically modified microorganisms. They are considered, but directly plant and animals will not be considered. And also it also includes seeds, varieties and species and essentially biological processes for production or propagation of plants and animals. Section 3K, the most important section for computer science background people. A mathematical or business method or a computer program per se or algorithms will not be considered for patent. Many a times we think if we write an algorithm, we can go and file a patent for it. So it is not so. If you are having a software, if you have developed a software, you can go for a patent. No. In USA, software patents are allowed, but in India, software patents are not allowed. In India, if you have an algorithm or a computer software, you can go and apply for copyrights, but not for patents. However, if you have come up with a software integrated with a hardware part, then you can go for filing a patent. So always remember, pure software cannot be considered for patents. Software plus hardware can be considered for patents. A literary, section 3L, a literary, dramatical, musical or artistic work or any other aesthetic creation whatsoever, including cinematographic works and television productions. So these form a part of copyright. So literature, drama, musical, films, everything, these form a part of copyright. So they cannot be considered for patents. Section 3M, a mere scheme or rule or method of performing mental act or method of playing games. So all these come under copyrights. Section 3N, a presentation of information. So it again comes in copyright. Section 3O, topography of integrated circuits. And section 3P, an invention which in effect is traditional knowledge or which is an aggregation or duplication of known properties of traditionally known components or components. So any traditional knowledge related invention, you're showing using of neem, turmeric, and showing it can be filed for invention, or it will not be considered because it is already existing as traditional knowledge in TDKL database. But however, you can use them and come up with a new product or process, then it will be considered. As it is, you are using the traditional knowledge, it will not be considered. So this was about section 3 and section 4. Inventions related to atomic energy will not be considered for filing the patent. So when you are going and filing patents, you should remember all these things. Section 3, very important section. It has subsections A to P. If you feel it doesn't fall under any of these category, and if it doesn't fall under section 4, that it is not related to atomic energy, and if it contains 3 important things: novelty, inventive step, and industrial application, then you can consider your application for filing a patent. So now I'll show you once, demonstrate one small video on patents. Naveen sir, screen is visible?
Yes, sir, it's visible, sir. You can play, sir.
So in this short video of patents, you would have observed many qualities of the product which he was demonstrating. The device could easily convert any cycle into an electrical vehicle with a lot of features like easy charging, easy to convert any cycle into an electrical vehicle, compatible. It was waterproof, it was fireproof, and it was efficient also with so much of charging, so many kilometers of service, so much of payload. So you can see lot of features were there in that particular product. So when you see such inventions which are novel, which and also you would have observed one code there, it is compatible with XYZ numbers of the cycles and auto rickshaws which are already running in India. So this invention can be used by all of them. So this is an example of industrial application. So it can be made in the industry or used by the industry, and it can be used for many people across us. So when you come up with any invention which is for the public, which can be implemented at the mass level, and which has all these qualities, it has inventive step, it was novel and industrial application. So such uh, inventions can be easily granted a patent by the government of India. Coming to the next category of intellectual property rights, that is copyright. So what is this copyright? This is one of the form of intellectual property rights. So if you post photos on Facebook, write emails, post videos on YouTube, then you are a copyright holder. And if you are playing Arijit Singh songs at your restaurant without his permission, you are technically a copyright infringer. So copyright is that branch of intellectual property rights which protects artistic, literary, dramatic, musical, and the similar works. The concept of related rights annexed to copyrights protect sound recordings, cinematographic films, and performers. So copyright is not a single right, it is a bundle of rights. In its simplest terms, copyright is the right to copy, but it is not limited to that. It is also the right to translate, to make adaptations, derivative works, etc. So copyright is an exclusive legal right granted to a creators on expression of an idea. So copyright owners has rights to reproduce, translate, adopt, perform, distribute, and publicly display the work, etc. Registration is not mandatory since copyright comes into existence as soon as the intellectual work is created. It is recommended to register a copyright for better enforceability since registered copyrights have evidentiary value in the court system. So books and other written materials, television, movies, games, music, all these forms part of copyright. So under literary, dramatic, musical or artistic works, the term of the copyright is lifetime of the author and until 60 years from the death of the author. For anonymous and pseudonymous works, 60 years from the year the work was first published. For works of public undertakings and government works, 60 years from the year the work was first published. For works of international organizations, 60 years from the year the work was first published. Sound recording, 60 years from the year in which the recording was published. Cinematograph films, 60 years from the year in which the film was published. So the things copyright does not protect. Copyright law only protects the ways the ideas are expressed in a particular creation. Copyright does not protect the underlying idea, procedure, method of operation, mathematical concept or system. Ideas protected under patent law or as trade secrets. So anything that comes under patent or trade secrets or designs will not come under copyright. They are mutually exclusive. Anything coming under copyright is not patentable. Anything which is coming coming under patent will not be copyrighted. And facts, copyright does not protect facts, whether scientific, historical, biographical, or news of the day. Only the manner in which these facts are expressed, selected, or arranged are protected. Others are free to use the facts as long as they do not copy the manner in which they are expressed. So if you are using any facts, you need to just cite the source of the data, source of the information. And there are copyright societies in India for musical works. The Indian Performing Rights Society Limited, IPRS, for sound recordings, Phonographic Performance Limited, for reprographic works, Indian Reprographic Rights Organization, for singers' rights, Indian Singers' Rights Association, Screenwriters' Rights Association of India, Society for Copyright Regulations of Indian Producers of Films and Television. So all these are different societies in India which are protecting the film industry or television industry. So what is the procedure for filing a copyright? So initially with the application form, wherein you are representing your idea along with the DD. If you are an individual person applying, it will cost you around 500 rupees. DD or e-filing also can be done. So once you file, and filing number will be given, that is called as diary number, and then the document will be checked by the controller of the copyrights. So within 1 month. So if there are objections by the examiner in relation to the work what you have done. So for copyright also, any work you are submitting will not be considered for registration unless it is novel and it is not against any morality or against any religion or any society. So your work should be novel. That is the first condition. Second, it should not be harmful, or it should not create any it should not disrespect any other religion. So it should not create disharmony among the people. So if it is not falling under that criteria, then examiner, after the scrutinization, if there is any discrepancy, he may request the copywriter to he may request the applicant to kindly do the changes. If there is no discrepancy found, they may directly issue the registration of the copyright. So now coming to the fair use or fair dealing of the copyright. So any act which can be justified by the fair use of the copyrighted work would be saved from the infringement. So to see whether there has been a fair use of work, there are 4 factors to be assessed. The amount of the content taken from the copyrighted work has to be seen. If the amount taken was substantial or qualitative, it will not be. For example, if I am getting 5 pages of any textbook xeroxed, that is fine. But if I am getting the complete textbook itself as xeroxed and I am using it, then it is infringement. You cannot call it as a fair use because you are completely you have taken the photocopy of the textbook. If the use of the copyrighted work in any manner affects the market of the owner of the copyright, it will not be a fair use. For example, creation of parodies does not affect the market share of the original content holder and could be justified under fair use of the work. The purpose and the character of the work indulged into by the alleged infringe has to be seen. Whether the copyrighted work was used for activities which are commercial or for activities which are non-profit in nature will determine whether the fair use exception will apply. For example, use your copyrighted material for education purpose, for teaching purpose, or for research and development purpose, then it will come under fair use. But if I'm making money out of your work, then it is an infringement. So the nature of the copyrighted work will also determine whether copying from and such work amounts to be an infringement or not. This is a question of judicial determination. So the concept of fair dealing is broader in scope as compared to the concept of fair use. It is not based on any factors test. Rather, it is based on the principles of equity. Fair use and fair dealing are used interchangeably at times. However, they differ broadly in scope. In determining whether there has been a fair dealing with a copyrighted work, the purpose of such copying is seen. If the purpose for which the copyrighted work was taken and used can justify the responsibility of the taking, then such act will be considered under fair dealing. For example, non-commercial works, private study, reporting current events, etc. are facts of fair dealing. So now coming to the next category of intellectual property right, design. Before that, I would like to play a short video on copyrights. Naveen sir, is it visible?
Yes, sir. It's visible, sir.
Most of us have seen the word or symbol for copyright hundreds of times. But what does it actually mean? Copyright is a type of intellectual property that protects creative works, like books, movies, songs, sound recordings, sculptures, and software. Trademarks and patents protect other types of intellectual property. A trademark is a tool that prevents a company from adopting a name or a tagline or a product configuration that is confusingly similar to that used by a competitor. Trademarks help consumers identify the source of what they're buying or using. A patent protects inventions and discoveries, ideas, processes, methods, concepts, machines, and devices, things like that. Patent law protects an idea, while copyright law protects the expression of that idea, the exact words or form chosen to convey the idea. Copyright protection is governed by federal law and has been a part of this country since its founding. The Constitution empowers Congress to enact a federal copyright law to promote the progress of science and the useful arts. Copyright law was seen as a vehicle for adding to society's wealth of culture and knowledge by encouraging the creation and dissemination of new creative works and information. Copyright does this by giving its owner certain rights over a work and its commercialization. The Supreme Court has recognized copyright as an engine of free expression. Copyright law can be found in Title 17 of the United States Code. So, what does it take to get copyright protection? First, a work must be independently created by the author. Second, it must have at least a minimal amount of creativity. And third, it must be fixed in a tangible medium. Back in 1790, works covered by the first federal copyright law were limited to maps, charts, and books. Today, copyright protection includes literary works, musical works and sound recordings, dramatic works, pictorial, graphic, and sculptural work, motion pictures and other audiovisual works, pantomimes and choreography, and architectural works. Copyrighted works do not include ideas, procedures, processes, systems, methods, concepts, and discoveries. Other things not protected by copyright include facts, names, titles, and short phrases, typeface, fonts and lettering, blank forms, and familiar symbols and designs. Copyright protects the expressive content of a work, not the underlying thoughts and ideas. To be sufficiently creative, the work must demonstrate some spark of creativity. The Supreme Court has said even a modicum of creativity is enough. The bar is low, but there is a bar. A fixed work is one that you can see or hear, or if you can't, at least some technological device can. It doesn't need to be permanent, but it can't be too short or transitory. There are some things, such as improvised performances, that have not been written down or recorded, that do not qualify. As soon as an original work is fixed, it is protected by copyright law. But registering the work with the Copyright Office is a great idea because it creates a public record of the work. Registration also benefits copyright owners. You have to register, or have had the office refuse to register, your U.S. work before you can bring a lawsuit claiming someone infringed your copyright. And a timely registration gives certain legal presumptions and allows you to seek attorney's fees and statutory damages in a lawsuit. Okay, so you have a copyright. Now what? Copyright law gives authors certain exclusive rights in their works for a limited time. For example, copyright owners have the exclusive right to sell their books, publicly display their photographs, or publicly perform their plays, or authorize others to do so. These exclusive rights do not last forever. Generally, they last for the life of the author plus 70 years, or, in the case of works made for hire or anonymous works, for either 95 years from the date of first publication, or 120 years from the date of creation, whichever is shorter. Works created before 1978 have a different term calculation. Users generally need permission before using someone else's copyrighted work, but there are several exceptions and limitations. Fair use is the most famous. It allows journalists to use copyrighted text in news reports, or for an author to parody another author's work. Another exception is the first sale doctrine, which allows the owner of a copy of a protected work to resell or otherwise dispose of that copy. Do you love used bookstores? That's the first sale doctrine at work. To learn more, including
So now moving ahead with the third category of intellectual property rights. Naveen sir, is the screen visible?
Yes, sir, it's visible, sir.
Okay.
Now it's a design PPT. Sir.
Yes, sir. So this is the third category of intellectual property right, that is design. So what do you mean by this industrial design? An industrial design relates to the appearance of an article, which results from features such as lines, shapes, colors, whether in two-dimensional or three-dimensional of the article. Designs are the aesthetic features of an article and is judged solely by the eye. Designs are applied on articles of manufacture. For example, a design applied to a cloth, design of a car, footwear, etc. So design is a shape, pattern, arrangement of lines or color combination which is ornamental in nature that is applied to any article. Design should be applied or applicable to any article by an industrial process, and the grant will be for a period of 15 years, 10 plus 5 years. So why do we need these designs? So to catch the attention of buyers, an article must be visually attractive. A normal appearance of the article may have an adverse effect on its marketability. A design reflects someone's intellect and creativity, which afterwards becomes a product. To design any product makes a long-lasting effect on the consumer's minds. A design helps the consumers to recognize any product. It adds value to the product and helps in gaining fair returns on investment. It gives you fair competition in the market. Legal protection therefore becomes necessary for the creation of new designs and their applications to articles. So when companies are competing at equal price and functionality, design is the only differential that matters. So suppose you have two items which are of the same functionality and at the same price. So the one which is more appealing to your eye, or the one which is more ornamental in nature, or the one which is more attractive, definitely customers will select that product because you have similar products, similar quality, same price. So obviously the external appearance plays a very key role in the final selection of the product. So designs relate to the appearance of an article, and apart from the utility of an article, its aesthetic appearance and design is a key factor which influences the purchasing decision of an individual. For example, a jeans is a garment worn on the legs. That is its utility. However, a customer might want to purchase a jeans which has been ripped because of its aesthetic appearance over a simple pair of denim, even though both perform the same function. Therefore, to successfully commercialize a product, companies invest heavily in terms of money, time, skill, and labor to create the perfect designs. Thus, it is important to give exclusive rights to creators of designs so that their creativity is rewarded and their investments in time and money are recovered. So giving design rights is beneficial to the consumers as well because they would be saved from cheap design imitators in the market and be assured of good quality products. So essential requirements for registration of design are eye-catching feature. It should be new or original. Application to any article by an industrial process not been disclosed to the public anywhere by the publication in tangible form or by use or in any other way prior to filing date or which applicable or where applicable the prior date of the application for registration should not be functional or useful, should not be artistic nature like painting sculptures, be significantly distinguishable from known designs or combination of known designs, not to be contrary to public order or morality, not to be prejudicial to the security of India. So when I'm filing a design, I'm just worried about the external appearance of the product. So you can see when we are filing a design, we require the different views of the product, like front view, side view, back view, top view, bottom view, left perspective view. So totally 7 views we require of any product to file a design. And this we can file online using government portal, online filing of designs, IP India website. And you can select what is the class of the application type. Again, you can select the subcategory like this and then give the title of your invention and then file it with the suitable form. So the fees for filing a design is 1,000 rupees. So you can apply for a design using e-filing or even offline mode facilities also. So these are few designs which were evolved during COVID-19. You can see different masks, different oxygen concentrators. So these are the external appearance. And a single product can have a patent, can have a design and a copyright for it. For example, if you consider your mobile phone, the mobile phone working, internal hardware, software, everything forms part of patent. But when I am concerned with the external appearance of the mobile phone, the aesthetic view, it forms the design. And when I am referring to the user manual of your mobile phone, it is a copyright. So a single product can have copyrights, it can have design, it can have a patent also. So it is not that it is different form. See, when it comes to intellectual property rights, the external appearance forms, the external appearance of the product becomes design. The user manual may become copyright, and the working principle, the invention, the product may become a patent. So like that, you can find multiple intellectual property rights in a single invention. Tata Nano car, it has more than 100 patents, more than 150 designs, and more than some 50 copyrights granted for it. Because it was a unique car. You can imagine someone manufacturing a car, selling car for 1 lakh rupees. Nowadays, to buy a two-wheeler, we require 1 lakh rupees. So if someone has manufactured a car with such low budget, obviously all the sub-components are unique in that. So in that way, it had got maximum number of IPRs. So now I leave the stage to Naveen sir for question and answer session, and I'm thankful to NSAM Degree College and principal sir and staff members for inviting me to give a talk on IPR.
Okay. Thank you, sir. I think I'm audible, sir?
Yes, sir.
Okay. I request any participants, if you have any questions, you can ask us. Hello? Okay. Sir, I have few questions, sir.
Yes, sir.
Sir, what are the pros and cons of implementing AI in road accidents, sir?
Okay. See, when we say there is positive as well as negative when it comes to any technology.
Yes, sir.
And when it comes to, say, suppose if there is a connection failure or a link failure, because everything is connected, networks, through networks it is connected. And suppose if there is a link failure or if any intruder tries to hijack your system, then it
Yeah.
will lead to disaster of the system, wherein you can also observe threat to human life.
Yes, sir.
So it will form a critical system disaster. So one should be very careful when they are designing any systems using AI/ML, especially in relation to its security aspect. You would have seen there are now in medical field, they say some of the operations are being carried out by the robots using AI/ML. But the security aspect has to be strengthened, because one small failure may lead to may cause us a damage to the life of a person. So that is we need to make sure the application areas where in the initial years where we can use it, and slowly we need to, once we are through with the security aspects, then implement it.
Yeah. Thank you, sir.
This is what I feel.
Yeah. Thank you, sir. Sir, one more, sir. So, what are the monopoly privileges, sir?
Yeah, monopoly privilege. When I say intellectual property rights,
Yeah.
when I say intellectual property rights, patent is granted for a term of 20 years. Design is granted for a period of 15 years. Copyright is granted for a period of 60 years. So in that duration, I have all the rights to stop others from using my invention. At the same time, I have the license to sell my product to other companies. And for that particular period, I will get the royalty once that intellectual property right enters the commercialization phase.
One, sir.
So
Yes,
when I
sir.
say patents are the monopoly rights, they also say IPRs are negative rights because you are stopping others from using your invention. But suppose if I have got the grant of a patent and I'm not using it at all, then after 3 years, if someone after 3 years of the grant of the invention requests government that I'm not using the invention and you can apply for compulsory licensing, I want that invention, then government, if they feel you are not at all using the invention, it is just dead, you are just got the grant and you are not getting it commercialized, or you are not using it, or not neither selling nor using, then the patent will be transferred to someone who has applied for compulsory license. And suppose if no, it is still dead even after making it compulsory licensing, others try to use it but they are not able to use it, that patent itself will be revoked after 1 year. So you will have to use the invention or give others to use it in terms of by giving it on lease or on terms and conditions. Otherwise, government itself will revoke the patent if it is found that it is not being used.
Okay, sir. Thank you, sir. Sir, there is one more question from the chat box, sir.
Yes, sir.
Our JPG Dhananjay, sir, is a head of language, sir, Department of
Okay, sir.
Languages. He's
Okay,
having
sir.
one question. This is with reference to the basmati rice
Yes, sir.
and the neem leaves, sir. Basmati rice and the neem leaves. As far as parents are concerned, we fail to get them as a patent. So, what is the reasons for failure,
Yes, sir.
sir?
So when it comes to the traditional knowledge, when it comes to neem leaves or turmeric, such kind of products, which are already known to everyone that it since ages that it has lot of properties for curing the diseases. So such already existing traditional knowledge, we cannot use it for filing the patents. And basmati rice, as sir mentioned, there are some products which can be applied for geographical indicators. For example, you would have heard the term Assam tea. When I say Assam tea, I refer that tea is originated from Assam. So that is GI, geographical indicator tag, which is assigned to some products. Similarly, you have Channapatna toys, you have Mysore silk, you have Dharwad pede. So like that, Kolkata rasgulla. So all these are forming a part of geographical indicators wherein you come to know the origin of that particular product through this intellectual property right. So that is GI. And when it comes to traditional knowledge related stuff like neem leaves, etc., so it forms a part of TDKL library, traditional knowledge library. So we cannot use them as it is. But however, if you come up with any new composition of any process using neems and any other some other product, when you are mixing it and improving the efficacy, reducing the side effects and giving the synergical effect. So as I say, if you are combining two products, 1 plus 1 is 2, but your invention should prove 1 plus 1 is 3. It should be a surprising result. It cannot be 1 plus 1 equal to 2, because it will become obvious to a person skilled in the art. It should become non-obvious. As you have seen in that cycle example, it was a non-obvious example. People would be surprised by seeing the effectiveness of the product which he has developed. So only in such cases the patents are granted.
Thank you, sir. Sir, one more question from the participant. Hello?
Yes,
Sir?
sir.
From Nazir Sultan, sir.
Yes,
So
sir.
what about copyright books where I can get free of cost copyright books, sir?
See, whichever book you textbook you buy, it is a copyrighted book only. So you can use it. But if any Xerox person, if he keeps the textbook, if he scans the complete textbook and sells it to thousands of students, wherein those 1,000 students are avoiding to buy that textbook, wherein the royalty would have gone to the publisher, from the publisher to the original creator of that book. So when you are spoiling the business or when you are infringing the copyright of someone else, then only there is an issue. I buy 100 books and using it, there is no point of copyright issue there.
Sir, can I get the books from library, any central library?
Yes,
For-
ma'am. You can, ma'am, any textbook you can buy, you can use the textbooks, but taking complete set of Xerox of that textbook is infringement.
Okay, okay, sir. Thank you.
And even if you take complete set of Xerox of that book and you are using it for some research and development purpose, to some extent that is also allowed. But if making copies like in Xerox shop, you would have observed they keep scanned all the textbooks and they sell it to students in a bundle, say 1,000 rupees for 6 textbooks, wherein otherwise it would have costed 3,000, 4,000. So you're spoiling the business of the original creator. So that is infringement of the copyright.
So one book means whole book I can Xerox for myself, not for
You
others.
can Xerox for yourself, but again,
to-
you are not doing business out of it.
Okay, sir. Okay. For reference, we can use
For
it.
reference, you can use it, but again, you should not sell it to others. Suppose I take some rare book Xerox and I sell it for double the cost. That is also happening.
Okay,
So
sir.
that should not happen.
Okay, sir. Thank you.
Naveen, sir.
Is it audible, sir?
Yes, sir. So there
Sir,
is
one
one
more
more
question,
question
sir.
from Vijay. Yes.
Vijay Jariwal, sir. What about
Yes.
the chat GPT created content in research law and many commercial purpose?
Yes. So this chat GPT, it is again using the keywords what we give, the data is collected and presented to us. Now, it does not mean that the data, whatever is presented to us, is authentic. And it there is one more disadvantage with chat GPT, which I have recently understood. Suppose I give a topic. Can you give me some notes on introduction to AI? I get some 3 to 4 pages drafted, but the source from which those data are taken, it is not mentioned or cited properly. So there is an issue with that. So we cannot be 100% reliable on any such chat GPTs which are available as of now. I think if further improvements happen in those kind of softwares, wherein proper citations is being done to the source and you are referring it, then I think it is more helpful.
I think any other questions, participants? I think no other questions, sir.
Okay, sir.
Okay. Look like we covered all our questions.
Okay,
Hello,
sir.
everyone, participants. Is there anything else you wanted to ask before I need to wrap up this sessions? Yes,
ವರ್ಕ್ಶಾಪ್ ಕಳ್ಸಿದೆ ನೋಡಿ ಇದೆ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಇವ್ರು ಅರ್ಚನಾ ಹಾಕಿರೋದ್ ನಿಟ್ಟೆ
okay. I think hello, ma'am. Okay.
ಯಾಕೆ ಮಾಡಿಲ್ಲ
I think we can end the session, sir. I think there is no other questions.
Okay, sir.
Yeah. So thank you so much, sir, for delivering wonderful speech to understand the following concepts. So implementation of IA in the real world and the copyrights, intellectual with examples, and the Copyrights Society of India, that is especially, sir, with that URL links, that is really helpful for us. And fair usage of the copyright work and fair dealing, that is also going to be helpful for our research work, sir. And special thanks to the playing that video, sir, for better understanding for the patents. It's really good video, sir. So if possible, can you please share that URL, sir?
Sure, sir. I will share the PPT and video streams.
Yeah, thank you. Thank you so much, sir.
Thank you.
I think we've come to the end of the session, and great. Thank you, everyone. We appreciate you being here. Thanks again for joining us today, and we'll see you tomorrow. We are starting the same session at the same time, 2:30 p.m. Okay. So tomorrow's we are topic will be Uma Maheshwari ma'am. The topic is machine learning algorithms and its implementation using Python. So I request all the participants to save the time, 2:30 p.m. So we are going to start the session tomorrow. And the feedback form will be sent to the WhatsApp group. So another few minutes, kindly go through this and please fill the feedback forms. Thank you, everyone, participants, and special thanks to you, sir.
Thank you, sir. Thank you for it.
Thank you so much, sir. Thank you.
Actually, I was not well today, so my voice is not good.
It's okay, sir. It's really it's a wonderful session. So we got so much information. Thank you so much, sir.
Thank you.
Yeah. Thank you, participants. See you tomorrow.